I am pleased to have you return to my Coin Lady channel. Mark Fagel, a former SEC lawyer, has stepped out to provide important details about the SEC versus Ripple case and the continuing legal battle between the SEC and Ripple. An acknowledgement and notice of attendance, default notice, has been issued out within the XRP community by the U.S. Court of Appeals for the Second Circuit. A great deal of debate has ensued due to this assertion. There is a widespread belief that it should be seen as a warning to the SEC on its compliance in the proceedings. The potential effects on future crypto legislation is something you're probably curious about. If you would want to know more, keep reading. Fagel clarified that the notice does not target the SEC's activities, but rather Chris Larsen, a co-founder of Ripple and one of the appellees in this lawsuit. Fagel emphasized the serious consequences of Larsen'S legal team's failure to submit the required notice of presence by the October 18 deadline, so the court granted a 14-day extension for compliance. Larsen'S legal team faces the risk of losing the chance to present oral arguments if the necessary paperwork is not sent in by November 5, which may severely damage Larsen'S case. The notice poses serious problems for Chris Larsen'S legal strategy. If Larsen'S attorneys fail to effectively represent him by the revised deadline of November 5, his impact on the case could be reduced. The importance of following procedural rules in high-stakes lawsuit is highlighted by this case, especially one as widely followed as SEC v. Ripple. According to Stuart Alderoty, Ripple's chief legal officer, the company plans to make its preliminary argument by October 25, 2020. This filing will dispute the decision of Judge Torres concerning the institutional sales of XRP. Then, the deadline for the appeal papers will come. The SEC has 90 days to react, which means the legal battle could drag on until mid-2025. The Ripple vs. SEC litigation is still experiencing unforeseen developments. In your opinion, what will come out of this? Despite the appeal by the SEC, XRP is still there. You can't call it a security. Despite the SEC's latest appeal in its case against Ripple, the agency did not challenge the court's ruling that XRP is not a security. Parts of the court's preliminary finding that favored Ripple concerning XRP are being opposed by the Securities and Exchange Commission. Form C, a pre-argument statement C, sales on exchanges and personal XRP by Ripple, CEO Brad Garlinghouse, and co-founder Chris Larsen were all parts of the SEC's civil appeal that was filed on October 16. Ripple's announced the appeal on October 17. Defense The appeal, filed by attorney James Frazier, requests that the court reconsider its rulings on these two types of X social media platform transactions. Stuart Alderoty, Ripple's chief legal officer, responded to the appeal from the Securities and Exchange Commission and said that the company intends to file its paperwork the week after that. The appeal does not contest the court's ruling that XRP is not a security, as Seth made clear in his reply. Larsen and Garlinghouse are alleged to have sold XRP in violation of securities laws and to have assisted and embedded violations of those laws, according to the lawsuit. The claims against them are centered upon aspects of the Securities and Exchange Commission statutes. The SEC states in the brief that it is challenging the court's decision to grant partial summary judgment to Ripple. This decision is about the way in which executives sell XRP on exchanges for reasons other than cash, and how Ripple distributes XRP in return for those reasons. The SEC stated in its appeal that these issues are to be reviewed in nova, which means from the beginning. Therefore, Eleanor Turret summarized the anticipated schedule for the appeals process in the 7 days after the SEC filed in an interview with Fox Business. After Ripple files its Form C, the parties will work out a briefing schedule. The Securities and Exchange Commission has up to 90 days to provide its first brief. As previously reported in July 2023, judge allocators of the U.S. District Court for the Southern District of New York issued a ruling in favor of Ripple, finding that XRP is not a security when sold programmatically on digital asset exchanges. According to Aldo, the entire briefing process is expected to continue until July 2025. In August, the court banned Ripple from violating the Securities Act of 1933 and ordered the company to pay a $125 billion civil penalty. This came as a surprise because the deadline for submitting forms to the SEC was unknown to attorney Jeremy Hogan until an update was made public, which has frightened XRP enthusiasts and caused widespread uncertainty in the neighborhood. Where can I find the most recent updates? Let's find out when the Ripple Visas case was adjudicated according to the court's order. Eleanor Tourette, a journalist for Fox Business, published a court document following the commission's initial appeal. The decision on August 7 was reversed. But because of a document that the U.S. Court of Appeals for the Second Circuit made public, the scheduled docketing of the appeal did not coincide. A resolution has been reached regarding the deadline, and the sex appeal notice was submitted on October 4 under docket number 2426. Prior to the production of this record, the community's views were significantly different, as indicated in the docket sheet. This litigation will continue until the SEC files its Form C, and we will make sure to keep you updated on any new developments. Once both parties have submitted their documents, the next step is to schedule a briefing. The SEC will have an extra 90 days to present its opening brief and legal stance, which should be completed by at least the middle of 2025. Despite the SEC submitting the notice of appeal on October 2, 2024, it was not officially docketed until October 4, 2024, according to a Fox Business report by journalist Eleanor Tourette. The Securities and Exchange Commission seems to have missed a crucial deadline in appealing the XRP litigation. Both outside observers of the sector and legal experts have engaged in a great deal of speculation to highlight this disparity. Tourette released a document indicating that the appeal had been filed on October 4, but this has sparked a controversy regarding whether the SEC must submit forms for the appeal by October 18, instead of October 16, as previously thought. So that she might have a better grasp of the situation, he reasoned that the final could be rescheduled for October 18 in accordance with the 14-day limit. Noting that she was soliciting feedback from important parties, she reaffirmed the timeliness of the deadline and promised a speedy response from XRP. According to Ashley Prosper, a prominent community member, the Army kept tabs on how people responded to Rhett's findings, and many individuals use the Second Circuit's agenda to estimate when things will happen. But he did tell us that the notice of appeal had been submitted with the district court when the Form CN deadline was being calculated. According to him, the filing date is the sole important consideration. Rather than being docketed in the Second Circuit on October 4, the 14-day clock began on October 2, the day it was submitted, according to the court's regulations. The idea had Prospero's backing, as he had promised the local Vincent de Paul's. Additionally, Code shared his thoughts on the subject. He raised issues about the conflicting dates and pointed out that the notice of appeal was correctly submitted on October 2. When asked about the deadline of October 18, he voiced his reservations. According to Van Code, the stated references are not legitimate and the date of the initial filing with the district court should be regarded as the final reference. The Securities and Exchange Commission may have missed the deadline, but the speculation centers on what may happen next and the consequences. A member of the XRP community noted on social media that the court can still accept or reject a late submission based on the filing date, which is relevant because XRP's value has started to rise again and a lot of people are talking about the deadline for the Securities and Exchange Commission to submit Form C. Seeing my video is an honor. Support my channel with a like and a subscription. Goodbye for now.